the repeal of the Jamaica Constitution Order in Council 1962 and the saving of the Constitution, even though we know that some would like the entire Constitution to be rewritten at this time, but that is work in progress. And for the benefit of those who are listening, to repeal the Jamaica Constitution Order in Council, we are invoking the deeply entrenched alteration provisions of the Constitution. And to achieve this goal, the provisions of the passed by the Parliament will have to be approved by the people. The repeal of the Order in Council will see a separation of the Constitution, which currently appears as the schedule to the order, and the publication of the Constitution as a separate document in Volume 1 of the laws. Insertion of the Preamble. Member Davis?
Yes, Madam Chair.
Do you have any views on the ask for indigenous people of Jamaica to be specifically recognized? The approach we have taken in the preamble is to provide very general words that would acknowledge the history and the journey we have taken so far. Instead of specifically mentioning a group.
Sorry, thank you, Chair. Well, you know that there is this principle that says the express mention of one is the express exclusion of the other. I guess it could be applied here, because by so doing, the approach that has been suggested and is what we intend to embrace is one that sees the group being mentioned without anything specific being said. So you don't want a scenario where very well later on there are calls to include other groups, other persons, but the all-inclusive, all-encompassing reference, I think, enables us to include these groups without any specific reference. But it means that no one is left out, basically. That's my view on it.
Yes, yes. We shared some perspectives in the ministry on the submissions that came in. And as is reflected in the minutes, we note that different groups call themselves the different names. So the Yuka, Yike, Yameye, Goane. I have to confess that I never heard of them before this constitutional reform work. And we know there have been changes in reference between Arawaks and Tainos. We also know that there isn't a settled view on the role of the Maroon. But if the ask is for acknowledgement of the journey we have taken so far, then that is captured in the proposed preamble. I remind everyone that we went through a process and we were expertly assisted in finalizing the proposal for the preamble. It doesn't mean that it can't be changed, But again, I commend the expert committee that did the work in pulling together drafts that were submitted, some of which had been submitted at the time of the making of the Constitution, and others which came along the way. All right? So it appears that the committee would recommend that no express mention be made of any single group. I don't know if members of the technical team wish to add anything for consideration. In respect of the repeal and replacement of Section 1 of the Constitution, repeal and replacement of Section 2, the insertion of a new Section 2A in the Constitution, we do not have comments, but Madam CPC, I note from the submissions of the Faculty of Law of the University of the West Indies that there are questions around how the clauses and the proposed sections would be numbered. We who legislate understand when a capital letter is used, but may I ask you to just explain so we can also put it on the record, because I realize that even in the teaching of the law, there seems to be ignorance about how sections are numbered when changes are being made.
Yes, so when amendments are made to existing law, we have to deal with a situation where there is an existing numbering scheme, because the original law would have been numbered serially 1 through whatever number of sections there are in the Act. So when we are making insertions, we generally don't disturb the numbering by renumbering when we insert a provision, because this could affect cross-referencing not only in the instrument that we're amending, but where cross-references are made in other instruments that refer to the Act being amended. And also, there's a possibility that the provisions may have been mentioned, for example, in case law. So to preserve the historical reference, we normally would, when we're making an insertion, not disturb the numbering, but we have a numbering scheme that facilitates insertions where, for example, if we're inserting a number between existing provisions, sections 1 and 2, we could insert a new provision as a new 1A between the existing sections 1 and 2. So that would allow for the numbering scheme to not be disturbed.
I think it is important for me to ask you to say it again, and also to specifically reference the use of the uppercase and the lowercase, and just to explain sections, subsections, paragraphs, how they go. The truth is that people don't know, and even among attorneys, they don't know. And I laugh when many believe that they can simply draft laws. And I recall you have been at pains to point out that legislative drafting is a specialized area, and it requires specialized training. And when I see questions raised about scheme of legislation, presentation, and ordering, I smile quietly, because those questions help to reinforce the point that legislative drafting really is a specialized area. So We also, during the deliberations, considered whether the constitutional provisions should be referred to as articles, setting it apart from the ordinary legislation, and I think is something that we will consider when we come to putting the complete revised constitution together. But for the members of the public and for those who are listening, may I just ask you to explain that numbering scheme and how provisions, the different category of provisions in a bill.
Right, so the numbering scheme utilizes, firstly, the Arabic provision sections there are, and those would be referred to in an act as sections. For a bill, it's clauses. Then when it's a section is divided into several legislative sentences, each sentence then would be a subsection. So that is the provision that you would have in brackets. So we would start out with the Arabic 1, and then the subsection, which would be numbered as 1 in brackets, would be subsection 1 of the section. Then that section could then be broken down as parts of the sentence into paragraphs, which would then be numbered from A through Z. And if the paragraphs are then broken down into separate parts, then we utilize the Roman numeral system. So it would be a subparagraph of paragraph A would then start with Roman numeral 1. And if that subparagraph is to be broken down into a part, then we would utilize the capitalized letter A. So that is usually how far we would proceed with the numbering system. And again, as I had explained before, when we are inserting a provision, normally we try not to disrupt any possible cross-referencing. So typically, unless we are able to check and determine that the cross-referencing would not be disturbed by a renumbering, we would insert a provision by adopting the number 1 followed by A. For example, if we are inserting between sections 1 and 2, then the new section being inserted would not be renumbered, as 2, and we would not renumber the remaining provisions as 3 onwards. Instead, in inserting between sections 1 and 2, we would insert the provision as 1A. And if it's more than one provision, then you could have 1A, 1B, 1C, and so on.
Of course, in legislative drafting, I think even those who interpreted the law would benefit from a refresher on this. That leads me to something else. The bill that is before the Parliament is an amending bill to the Constitution. And when it is passed, it will be read and construed as one with the Constitution. I note sometimes that even trained persons are not sure how to reference an act of Parliament, amendments coming from that discrete act in relation to the principal act. Can you explain that? Okay. So these would be the 2025 amendments to the Constitution, or you can refer to the bill by itself. But they're also part of the Constitution once it's consolidated. I think the fact that we have not been printing consolidated copies of the law and amending bills still appear in the discrete acts of Parliament, there seems to be some confusion in how to refer to the discrete act which amends a principal act and how they come together.
Well, notwithstanding that they might not have reached the point of consolidation, because the Act is to be read and construed as one with the amendments effected by the Amending Act, then the provisions would be read as amended by the Amending Act. So you then, for example, if we are inserting or amending a section, it's to be read as if you had written over the section with the amendment inserted. So you would not really be reading the act as is and then referring to the amending instrument separately. So really what you ought to be doing is by hand even writing in the amendment as directed by the Amending Act. I don't know if that is clear.
It's important because at the end of the day, the amendments being made will have to be approved by the people. And there is a school of thought which says that we must do the work in a way that makes it easy for the people who will do the approval to understand the provisions. And as far as possible, the approach in the bill is to repeal and replace and to save the ordinary man who will vote to approve it from having to cross out and write in the section the amendments, except where we are changing a single word. So it's important that there is that we provide. We help the people to understand the process that is being used, because we truly are in uncharted waters. It's not just the Parliament that will make the changes, but the changes have to be approved. And I think for those who continue to reiterate and emphasize the importance of public education, this is one area where the case is well made. All right. I note that the proposed amendments to achieve the goal of patriating the Constitution and the process of Jamaicanizing the Constitution, those provisions have not been the subject of controversy or much comments, except, of course, the preamble, where the ask is for specific mention. But it's important for everyone to understand that we are pursuing not just the goal of changing the head of state, but of putting the supreme law of Jamaica in proper form, and to have the Constitution standing on its own as an act of the Parliament backed by the will of the people of Jamaica. Very important goals being pursued, and there is no dispute or controversy between government and opposition in the pursuit of this goal. It may matter more to some than others, but it is widely accepted that putting the Constitution in proper form is something that must be done to further the cause of independence. And successive administrations have agreed on the importance of this goal, but have not taken the step to achieve it, because in order to achieve it, we have to activate the most difficult alteration provision of the Constitution. But ladies and gentlemen, wherever you are listening and paying attention, when we set goals for the right reason, we have to find what it takes to pursue those goals and to achieve them. And that is what we are doing in this reform process. All right? So there does not seem to be any recommendation for alteration in respect of the first 8 clauses of the bill. We go to Clause 8, the repeal and replacement of Section 9 and 10. All right. May I just ask the supporting team to assist, Ms. Mills? Recommendation from Mona Faculty of Law in respect of Clause 8.
The recommendation states, the proposed Section 8.2 allows for the deprivation of citizenship for those who are not Jamaican by birth, descent, or registration as a citizen based on marriage to a citizen of Jamaica. However, to align with international human rights obligations, such as the 1961 Convention on the Reduction of Statelessness, should there be an explicit provision stating that no person should be deprived of Jamaican citizenship if it would render them stateless. And there was an additional question in the submission about whether citizenship by descent should be clarified, whether there should be a definition limiting citizenship by descent.
Can we just pull up the 1961 Convention on the Reduction of Statelessness? So the issue of deprivation of Jamaican citizenship arises controversially in cases where someone is invoking an entitlement to Jamaican citizenship in circumstances where that person also has another citizenship and is facing deportation. That is the real problem case for Jamaica, because the Constitution allows for citizenship by descent. We have seen cases where, though entitled, that citizenship has not been acquired formally, and where the person is a convict and is facing deportation, in particular in the North American context, they then invoke the Jamaican citizenship. And we know that Jamaicans, the question arises, if you have another citizenship and you are not otherwise attached to Jamaica, and the only time you want to invoke Jamaican citizenship is when you're facing deportation after having been convicted of a crime. Should the state be given the power to make an assessment and determine what is in the best interest of Jamaica in such a case? That is what it boils down to. All right. I'd indicated that before we make a recommendation, we would invite the CRC to also share some perspective. Just to make it clear, though, that at this stage, the committee that takes primacy is a joint select committee, not the Constitutional Reform Committee. So that is the real question, is whether in specified circumstances, power should be reserved to the government to deprive citizenship where the interest of the state would be injured instead of, or harmed instead of helped. We had submissions from the PICA on this matter, but I'm not seeing it. All right, just recalling that the Passport, Immigration and Citizenship Agency that appeared before the committee had also shared some information about the challenges posed in circumstances where persons facing deportation want to invoke their Jamaican citizenship in circumstances where it would not render them stateless, but would impose a greater burden on the state.
We also wanted to mention that in relation to the Convention on the Reduction of Statelessness, that Jamaica had entered a reservation stating that we were not accepting the obligation to expressly state that in our legislation. So I guess that's something to be borne in mind. Okay.
No, I'm going to ask you to just repeat first of all, for those listening, so there is a convention, just to provide a little bit of information about the convention, to which Jamaica is a state party with a reservation.
Right. And that reservation states, upon acceding to the Convention on the Reduction of Statelessness, the government of Jamaica declares, pursuant to Article 8 of the Convention, that it retains the right under its laws to deprive a person of his or her nationality in the circumstances outlined in paragraph 3 of that article. And then in paragraph 3 of that article, it contains the obligation to expressly state that the contracting state would not render the party stateless.
All right, so we need to explain that.
Right, that
in
there are
layman
grounds
terms.
under which we can still do so.
Right.
So we had reserved.
Right. So that Jamaica is saying that it is not giving up its power to refuse citizenship to someone where that person has another citizenship, and also where it would become a problem for the state. It's important for those listening to appreciate that this matter is a matter that has come some way. Amendments were made to the Constitution in the 1990s, and I know that those who fought for those amendments did so in circumstances where their descendants would not be entitled to Jamaican nationality. The intention is not to disturb those gains, but to recognize that over time we have seen threats to the state of Jamaica and threats to the communities, and just burdens being placed on the national purse in respect of people who are born and raised in other jurisdictions, socialized, chosen a life of crime, and then when they are to face the consequences, they want to dump the burden on Jamaica and Jamaican people. And we also know that we've had serious challenges with some who have been involuntarily returned to the jurisdiction. So this matter is a matter of importance. To summarize the question is whether in specified cases there should be power reserve to deprive someone who would otherwise be entitled to Jamaican citizenship of that entitlement, where the risks and the burdens would outweigh the benefits. I don't think there is any other comment on that provision. Yes?
To address the other aspect of the comment that was made by the law school about the need for definition of dissent. I just want to draw attention to the fact that the proposed new section 10C is empowering Parliament to prescribe the grounds on which and the procedure by which a person may become a citizen of Jamaica by descent. So because of that, it would not be desirable here to insert a definition for descent, because that is being left for Parliament to prescribe in the law that's being empowered to be made. Also, yes.
So the related issue is whether the entitlement to citizenship by descent should remain limitless, regardless of the degree of descent. And that question arose generally and also comparatively in relation to the provision about the citizenship criterion of a nominee for president, where that person, if a citizen of Jamaica by descent, would only be eligible if he or she acquired the citizenship from at least a grandparent. I think that's the related issue. But the point you have made, Madam CPC, is one that is, again, worth reiterating, that not everything will go in the Constitution. The Constitution is going to be supported by acts of Parliament and regulations all the way down the hierarchy. Constitution is supreme, and then below it we have primary legislation, which are the acts of Parliament. and Parliament is being empowered to set out the details in respect of the process, procedure, and all other things for the acquisition of citizenship by descent. But I think the question that may arise is whether, what are the restrictions on the Parliament in respect of that? I think that is what we probably should look at.
It's subject to the provisions of the Constitution, which would have set out already some provisions entitling a person to citizenship by descent. So I would think those would automatically be the restrictions.
If a recommendation is being made to reserve the power, then the constitutional provision itself would have to be reworded differently, because as it is wide open. And if it says that if you acquire citizenship by birth, by descent, or marriage, you cannot be deprived of it, then the Act of Parliament could not prescribe anything that would restrict that right. So the section, if the recommendation is being made and is accepted, would have to make it subject to the Parliament's power to prescribe the details. Because if that is not made clear, then you could not thereafter limit it. Is that right?
What the policy is, yes, if that proposal is accepted. But the way I read it, that provision was automatically saying, well, it's saying that you can't right now. The provision empowering Parliament to make the law could not deprive. But yes, if it is a policy that, I think then the provision would need to be amended.
Right, and so it is the care that has to be taken first in being clear about what the policy intent is, and to ensure that what is provided for accurately reflects that. Otherwise, we will find ourselves with problems between what the Constitution provides for, what the extent of the powers of the Parliament can do, and what the wishes of the people are. So, this is a matter that will require further consideration. Just to summarize, is that two related issues are being considered. If the intention is to reserve a power to deprive someone of Jamaican citizenship in specific circumstances, then that would have to be stated in the Constitution, to deprive someone who would be entitled by for example, dissent. That would have to be stated, because currently what is being proposed is simply for the Parliament to be empowered to pass laws to set out the process and the procedure by which deprivation can take place, but that would have to be done in the context of what is permissible. Constitutionally permissible, that is. All right. Any other matter to flag on this? If a decision is taken to limit the degree of dissent, then that can be done by an act of Parliament, or it can be specifically set out in the Constitution. It would be a matter of policy to determine where. But the intention is not to put all the details in the Constitution, but to put the broad principles and the limits that would be placed on the legislative power of the Parliament to make provisions in respect of citizenship. Right? Anything else in respect of the citizenship provisions? Yes?
Thank you, Chair. Just to suggest, from my reading, in order for us to make any change to the, to allow Parliament to make provisions with respect to dissent, we would have to amend 3C, which doesn't allow us any latitude. So as long as that provision remains intact, we wouldn't be able to go, I don't think we'd be able to go any further.
Thank you, Mr. Cross. We're saying the same thing, that if the intent is to reserve the power, then we would have to make that provision in the Constitution itself, because currently it does not allow for it to be done. We have no submissions on Clause 9, which repeals and replaces Section 11. We go to all right, just a minute. I think the way you have set it out we need to focus on the clause of the bill and reference that to the proposed section of it. So, Clause 9, Clause 8, and then when you go here, Clause 10, all right. Clause 10, amendment to Section 12 of the Constitution. Ms. Mills?
The new section, this is the recommendation. The new Section 10C allows Parliament to prescribe the grounds and procedure by which a person may become a citizen of Jamaica by descent. Well, here's the question again. So, however, the term descent should be clearly defined in legislation. Does it only apply to first-generation descendants of Jamaican citizenship? How is citizenship by descent given or determined? I'll go to the next question since we already discussed this. It states, many Jamaicans hold dual or multiple citizenship. particularly in the UK, USA, Canada, and CARICOM states, the law should specify whether renunciation of Jamaican citizenship automatically affects Jamaican-born persons who later seek to reclaim it. There should be a clear reacquisition process for former Jamaicans who wish to regain citizenship.
Right. It does appear that we would have to go a little further and not just prescribe the process by which you can renounce, but having renounced, the process by which you can reacquire the citizenship. All right, so we can make a note of that for the, I'm sorry?
That could be done in ordinary legislation instead of having to encumber the Constitution with a whole process about what would happen if somebody renounces citizenship and whatever.
I was not suggesting that it be placed in the Constitution, but simply that what Parliament is being empowered to do would reference not just revocation, but also the reacquisition, not for the process to be set out. So currently the provision only speaks to the deprivation and not the acquisition by dissent, but we're talking about reacquiring it after you have renounced it.
Right.
So it's not for those details to be set out in the Constitution itself, but for the clause empowering the Parliament to pass the laws to specify what it is that Parliament is being directed to pass laws
Right.
in relation to.
I wasn't suggesting that you were saying it, I was just responding to the comment that they raised.
Right. Right. So some are calling for every detail to be placed in the Constitution. We have to ensure that our institutions of learning and teaching about the law also have a perspective on what is properly for the Constitution and what is for other laws lower in the hierarchy, and how the principles set out in the Constitution relate to the power of the Parliament to pass laws on a subject matter. What I see from the submissions is that there is not clarity on that. Some of the matters that have come, I don't know if the students have been given a little project to make the submissions, and so they perhaps do not have the knowledge and the experience on these matters. But I want to ask the faculty and the law school to pay particular attention to what comes because of the authority, right, that you have as an institution imparting knowledge on these areas and training people to be qualified. Naturally, deference is going to be given, but when we see submissions that beg the question about a proper understanding of the issues, then we will have to have another conversation on those matters, right? So the simple point is that the Constitution is not the place to load up your details. That's why we have a hierarchy of laws. The Constitution sets principles. But we also know that what we have discovered from this constitutional reform process is that some of the things that have made their way into the textbooks on Caribbean constitutional law are at odds with the records of the Parliament, the verbatim records of the Parliament. And so we're going to have to rethink some of and correct some of the matters. I just crave everyone's indulgence briefly. Sorry about that. So just to summarize, in respect of the citizenship provision and chapter 2, which deals with citizenship, is whether the provisions should be revised to reserve a power to deprive citizenship in specified circumstances, and what would be those specified circumstances. Just to say that this is a matter that would have to be treated with great care and great caution. There is no intention to deprive those who pride themselves in their Jamaican citizenship by descent, to change that because of the nature of our people. But we also want to say that we want Jamaicans to be law-abiding people, and all who wear the nationality of Jamaican to be respected as law-abiding people. And not that we're going to have the whole nation being punished and have immigration restrictions because of the acts of a small number of people, which really is what it is now. Every time a Jamaican commits an offense overseas and is convicted or is caught in illicit runnings, the entire nation is punished for that. Right? That is what caused travel restrictions to be imposed on Jamaica, visa conditions to be imposed on the whole nation because of the acts of a small number of people. Going forward, as we relay the foundations, we will have to sort out what will the name Jamaica stand for, and when you raise the Jamaican nationality, what does it mean? Right, so we know already that the provisions relating to citizenship will come under review. Right, we go to the I'd like to come back to the provisions in relation to the president, because that's the biggest part. The bill is dealing with two big issues. Every clause is important, and every goal that we are pursuing is important. But if we were to place them in hierarchy, the two big goals are putting the Jamaican Constitution in proper form for a supreme law, and then transitioning from a constitutional monarchy to the republic, replacing the monarch as head of state with a president. Those are the big ticket items. And the also big ticket items is to make the alteration provision less difficult in order for us to achieve the remaining reform goals. So let us go to the submissions on the other provisions, and then we come back to the Office of President. A related question that is asked by the Mona Faculty of Law, whether it is being proposed to allow dual citizens to serve in Parliament, except for the Prime Minister and the Leader of the Opposition. And it says consideration should be given to a minimum educational qualification for members of Parliament. Well, the issue of minimum qualification for Parliament has been a contentious issue from the dawn of time, as we moved away from rule by divine rights and to make people to make the ordinary man in a democracy being eligible to serve. We do know that given the nature of the parliament and the work that needs to be done, you must be able to read and write and you must be able to reason. And we also know that in the Jamaican context, we have many sensible who, for circumstances beyond their control, did not achieve a formal education. Do we want to say that because you do not have a degree, you are not eligible for membership in the parliament? I don't know that that is what a Jamaica like this would want. Naturally, we want people to be able to read and write and reason and to conduct yourselves decorously. But minimum educational qualification, what would that minimum be?
Well, their argument is that since the parliament has required the rest of the country to have at least a basic, a minimum education of at least up to sixth form, that should also be what parliamentarians are required to have to enter the parliament. So that's their suggestion, that it should be upper six as the basic minimum level.
Certainly, we wouldn't want to say that because someone who is championing the cause of others does not have all of what that person recognizes to be important, then you don't have the right to champion that cause. It's like saying to a mother who did not have the benefit of formal education, don't tell me that I must go to school. Don't tell me that I must get a profession because you didn't have it. It's not a simple argument, you know. Well, what would the minimum qualification look like? Currently, there is a minimum educational qualification. Should be able to read and write English language. Let me just answer by saying that there is a minimum educational qualification. And there are people who would be otherwise eligible to serve, but maybe did not come up at a time when that compulsory requirement for education up to the sixth form, meaning for all of your minor years until you attain the age of majority. Yeah, we currently have members of this parliament who do not have tertiary education and who have been contributing well to the parliament. We do. And what do you say to the people if they say that I am prepared to support someone who I believe will represent my cause and my interest, since it's not a direct democracy, but a representative democracy? I don't know that this one would provide any easy answer, but I think the issue can be dealt with through the selection of candidates for election and to ensure that people are trained. I should point out that something good has been happening since the administration came in 2016. Number of parliamentarians on both sides have been sent on formal training for parliamentarians. We have programs in Canada and in the UK, and we have a number of sitting parliamentarians who have benefited. And I know that the goal of Prime Minister Holness is to ensure that all parliamentarians receive essential training in respect of the role. So we're making progress in this regard. We do want or parliamentarians and all officials to be appropriately equipped for the tasks assigned. The question of whether it is being proposed that dual citizens serve in Parliament, except for the Prime Minister and the Leader of the Opposition, is not a straightforward question or answer. We know this matter has been a matter of much excitement in relation to the current leader of the opposition. And we know that in the jurisdiction we have had litigation on this matter. And the thing about multiple citizenship is that it requires some allegiance to some other state and some other power. But we also know that people can be entitled to citizenship without doing anything on their own. In the same way that we have citizenship by descent, no one chooses his or her parents. And if you are born where your parents' nationality allow for you to acquire it as a descendant, then that's not something you would have had control over. And so the framers of the Constitution, in their wisdom, provide for something that you must do by your own act. So it has to be your own act, not something over which you have no control. So the answer is that people entitled to other citizenship than Jamaican can sit in the Parliament, and we do have people now sitting. The question is whether by your own act you are under a duty of allegiance or acknowledgement to a foreign state or a foreign power. When we are making a constitution or we are making any law, we have to have regard to the nature of our people. And in fact, at the time when the Independence Constitution was being made, it very much had regard to the nature of the people. People of Commonwealth, people with a shared heritage of being under colonial bondage, under the rule of the monarch through the colonial experience. And it brought together a framework of commonality. So now we have to have regard to our people and who Jamaicans are coming out of this heritage and out of this background. Right? So we have retained the test of conflicted allegiance and not dual or multiple citizenship. So it's a narrower provision. It's what you have chosen to do, because for some roles there can be no divided loyalty, none. No 1 foot in and 1 foot out. No divided loyalty. Right? Any other issue from those submitted? The leftist group, Jamaica Lands, is demanding a right to recall members of parliament. The issue of the accountability framework in the parliamentary cabinet system is one that many Jamaicans are not familiar And the weaknesses of the parliamentary system have been more on show than the strengths. We assume the strengths, and then we make a lot of noise around perceived or real weaknesses in the system. So, for my part, in my role as the minister with the subject matter responsibility and as also part of the government, we appreciate the genuine concerns about accountability in public life and accountability in private life too, generally about accountability. We will have to spend some time as a society looking on the role of your parliamentarians. Members of parliament are legislators. But for all of the years of mash down, pop down government, people have come to see a member of parliament as their first point of contact with government. And there is the expectation that the member of parliament should discharge the functions of the whole of government. So they call on you to be the Ministry of Labor and Social Security, and for you to be the welfare officer and the social worker. They're calling on you to be the priest, calling on you to judge causes, to be judge, jury, and executioner all at once. They're calling on you to be the bankers, to be the lenders, everything. So in this context, where we are yet to have the conversation publicly about who is responsible for what, when I make representation for a road to be fixed, and I advocate and I get the monies appropriated because the arrangement of government would say, here is a road program, whether it's Spark, Reach, or anything, and monies are sent to it in the budget process. I don't physically fix the road. I don't do the assessment. I don't have the engineering qualifications. I still have to wait on the NWA, if it's a main road, to get it done. So an angry constituency, where constituents are experiencing bad roads, for example, because a lot of roads have been fixed. When they say, I want to recall the MP because my road is not fixed, is that a proper basis for recall? Or if they say, but I beg the MP some money to fix up my roof, and you don't get it because the funds are not available, is that a proper basis for recall? I think on this issue of the recall, what would we recall for?
Thank you, Chair. I don't want to speak on behalf of Lands, I obviously can't. But they had proposed a fairly complex system of recall, which would be based off of just a petition. So it's not that there would be a basis per se that the roads, you're not happy with the roads, you're not happy with the facility, but that they would assess the number of persons who had voted for that had come out to vote for the particular MP. And then if a petition is received by a certain number that's greater than that number, then it would be a valid petition. And then depending on how many people vote yes after the fact.
Sorry, if the number of persons petitioning is greater than the number of persons that voted?
Well, let me read the proposal, their proposal. If a petition is submitted by a number of voters from a constituency where that number is greater than the number of votes received by the Member of Parliament in the most recent election, then a yes/no vote is held on whether to allow the Member of Parliament to remain in office or to remove the Member of Parliament from office. This petition would have to be signed only by registered electors in that constituency, with their participation in the petition verified by the electoral authorities. Then, if more persons vote yes than no, the seat is declared vacant and a by-election is then held.
Sounds good theoretically. How will it work? Can you imagine? We may end up with a parliamentary life where every year you have a by-election or every month, every 2 months, every 3 months. That is not to say that we do not need a proper system of accountability. What I have seen is that a lot of the issues raised are proxy issues for other things. So a lot of people believe that when they do not vote, anybody else who is voted in is not legitimate because their vote did not count, or their vote was not a part of the vote. And so we get called for direct election. And then the question is posed, for those that you directly elect, do you feel a greater sense of accountability or not? We have to look at this matter a little differently from how we have been looking at it. The fact that this round of reform may not give everything that is being asked for doesn't mean it's the end of the matter. I want to make that clear, because the truth is that we are making good strides in the right direction, and many people have become excited. They want it done all at once. But we can have it all, but maybe not all at once. And that's why we're taking the journey steadily, cautiously, and deliberately. Yes. We know that the parliamentary opposition already has indicated that it wishes to see a system of impeachment for parliamentarians in the Constitution. That issue is not going to go away. Doesn't have to be in the Constitution, or we have to look at what is the most effective mechanism for holding parliamentarians to account. It's not just the parliamentarians, though, it's for holding the people to account. Because what you see in Parliament is a reflection of what is in the society. And if we're a people who love impunity, we want to do what we want and just get away with it. But what then should set apart the Parliament, where we pass laws for peace, order, and good government? These are questions that we will have to deal with and reconcile. All right. So let us look at the recommendations that have come in and the submissions on the proposed changes to the Parliament. I know. 15, 17 of the matrix. We have submissions from the Mona Faculty of Law, Jamaicans for Justice, Jamaica Lands. Yes. What?
We propose, all right, I think there are some issues with this matrix, so I'm going to go based on the general questions that we have here. So several groups propose that directly elected Senate. They argue that this is justified to ensure proportionate representation in the Senate, as well as participation by the people in selecting senators. An alternative selection process was also proposed that would include a fairly complex system of voting on slates, which would contain the nominees put forward by the various parties as well as independents. And in this proportional system, seats would be awarded based on the number of votes on a slate. Some stakeholders are objecting to the proposal for an expansion of the Senate, as they believe it would be worse than the existing model. They argue that the government is overrepresented in the Senate and the opposition is underrepresented. The revised Senate as proposed by this group is seen to give, the revised Senate as proposed by the bill is perceived by this group to give an even greater overrepresentation to the government. And they're of the opinion that a 14-10-3 arrangement, which sees 14 senators appointed on the advice of the Prime Minister, 10 appointed on the advice of the Leader of the Opposition, and 3 in the President's discretion, would lead to a better arrangement than the proposal that's in the bill. One group was mentioning the 2/3 requirement for the vote, stating that the aim of that requirement is to maintain a level of balance where no single party could unilaterally control legislative processes. They're of the view that with 15 government-appointed senators plus 3 from the president, that a 2/3 vote could be achieved without the need for opposition support. That the restriction in Section 49 is acknowledged, but that this should be the position for all votes that require a 2/3 majority. They've stated that in keeping with the democratic process, that the Senate should be differently composed, that registered voters should be given the opportunity to appoint 3 members of the Senate instead of the president, being given this opportunity. Another group said that the current 13-8 split, which is 13 appointed on the advice of the Prime Minister and 8 on the advice of the Leader of the Opposition, they consider our current situation to undermine democratic principles. They've stated that it limits genuine debate and oversight, and that the President should not be allowed to appoint any members of the Senate because there's a high risk of political influence there. Another group stated that the composition of the Senate should be appointed to 15 government, 9 opposition, and 6 independent senators instead of the 3 as proposed. They're stating that this arrangement would create a more balanced and independent upper house, and that alternatively, proportional representation could be used as a model. Instead of the president selecting senators, that a non-partisan selection committee should be formed, and functional constituencies based on sectors of society should be set up. There are also other questions about what will happen to the senators who have been appointed by the president when the parliamentary term ends. There's a question around whether their seats become vacant, requiring the new nominee to make these appointments again. There's a question
When the
around
parliament ends, or if the president's tenure ends before the life of the parliament?
So there are both questions. I'll
Okay.
tell you again. So the first question is about the president when the parliamentary term ends. And there's also a question about when the presidential term ends or when there's otherwise a change in who holds the office. Whether the 3 senators appointed by the outgoing president would automatically lose their seats, and if not, how long do they stay in office? Would they stay in office until the end of the term, the parliamentary term, or is it that the new or incoming president can replace these senators with their own choice of independent senators? There's a question around when the new president is being confirmed by the Houses of Parliament, if this process would include all 27 senators, including the 3 that were chosen by the outgoing president, or if this process would only allow the 24 senators that have been chosen by the Prime Minister and the Leader of the Opposition. And if it's the latter, how many senators would count as an absolute majority of the Senate? Would it be 13 of the 24, or would it be 14 of the 27? And so those are the questions that have been raised.
Let me thank everyone who has submitted. I think some important questions have been raised. And we also know that for some time now, proposals have been made about changes to the Senate. It's important to appreciate that in the Jamaican context, the Senate was assigned a specific role, which boils down to being guardian of the entrenched provisions of the Constitution. And that guardianship role comes from the requirement for the vote of at least one senator from the opposition benches voting with the government to make changes to the entrenched provisions of the Constitution. We have seen how that has played out in the jurisdiction in very recent times. So it's a good thing that Jamaicans have seen the Constitution at work in respect of the need for opposition participation on matters. And it has shown not just one thing, but a number of things. One, the importance of collaboration and cooperation, the importance of viewing some things above narrow partisan dispute, matters that are in the national interest. And we have also seen how proposals from a government can be derailed in a space where an opposition that has no duty to govern and has no desire to cooperate can thwart things. So we have seen different scenarios played out. What is clear is that for us in Jamaica, we accept that the Senate should continue to play that role of guardian. And with that as an important foundation, we then look at the proposals for changing the Senate. The question of a directly elected Senate has been raised from time to time. But a non-elected Senate came about not only because the system is modeled on the UK system, but a recognition that there are many people who are capable and willing to serve, but who do not wish to go through the election process. We have to consider whether there remains a proper place for that in Jamaica as we seek to respond to the call for an elected Senate. Now, it is true that some people who serve as senators display the kind of partisanship that you would expect from the elected House of Representatives. And because of that, it begs the question as to what is the difference between the elected House of Representatives and the appointed Senate. The appointment to the Senate of those who contested and lost elections is also an issue that has been raised. The election to the Senate of people retiring from the House of Representatives, whether those practices are in keeping with what the appointed Senate should be. I think those are the questions that we should answer. You know, because it was not intended that the Senate would be just as partisan as the elected House of Representatives. But many times when you turn on the television and you watch the deliberations, you may even wonder whether the partisanship, the display of partisanship is not greater there than it is in the House. So we have to appreciate that the concerns are genuine. So the Senate was intended to be a more deliberative place where wider interest, the wider national interest, and wider considerations than the partisan perspective would be taken into account in deliberating on matters. And then there is the other issue of how much power do you give to an anointed body over those who are elected in a democracy, where the foundation of your parliament is a freely, periodically elected legislature. These are issues that we have to talk about and find answers to. So in the democracy, you know, it's not really meant to put anointed people over the elected people, but you do need the elected people to continue to earn the trust and confidence of the wider public. And that's what we have been having issues with in the jurisdiction. So the constitutional reform is a time of reckoning because it has brought to the surface a number of issues and a number of things that have been bubbling and boiling below the surface. And it is providing us with an opportunity to relay the foundations and to rebuild them. Now, in making the recommendation for the 15, 9, and 3, which is what we have, a lot of consideration was given to the formula that would preserve the requirement for at least one member from the opposition benches to vote along with the government to pass any bill proposing an amendment to the entrenched provisions of the Constitution. And we looked at different formula in order to preserve what we understood the people of Jamaica to accept for the role of the Senate. So the formula didn't just come up like that. All right? And there are many people who delight in controversies and roadblocks and gridlock. And they think that it's exciting when you don't have the burden of governing and the burden of discharging functions. It's all good and well. When you sit on the sideline, you can be jumping and get all excited. But the business of government has to go on. And we see so often, comparatively in the executive presidential system, where you have gridlock and shutdown, can't pass budgets. Business of government must go on. Business of government is a business of serving the people. So in designing our process, it's not just to have talk, because we like to talk as a people, but it's to ensure that at the end of the day, we can get things done. We don't pass laws just for the sake of passing laws. We have to get things done. We can't design processes and systems that sound good and provide excitement, and at the end of the day, you can't get the work done. Or that the work is so dragged out that everybody gets exhausted. Already, we are grappling with the length of time it takes between decision and implementation. So I just want to say to you, my fellow Jamaicans, that it's not spectacle we're creating. We want efficiency in our processes. We want people to occupy positions who have a sound understanding of what their role is and what the functions of their offices are. So a directly elected Senate is going to do injustice to the principle that we are reserving a place to have suitably qualified Jamaicans serve without going through the rigors of an election. The contention about a disproportionate representation of opposition and overrepresentation of government has to be looked at regardless of who forms government and who forms opposition. I don't know if people are saying that you want an opposition, again, regardless of who forms opposition, that is going to stand in the way? Or do you want a government that will responsibly discharge its functions and get things done in the interest of the people? Maybe the use of the word opposition connotes the opposing. Maybe that's the wrong approach. Because you have to have a formula to make things work. And that's why there is a majority rule. If the majority says, doesn't mean that you're disregarding views of the minority, but you have a process that is legitimate and facilitates things being done. And you don't want, they want the people, Ms. Mills, they want the elected people to determine who would go in the Senate. But in effect, that is what happens when you give the power to a prime minister to make recommendation and you give the power to a leader of the opposition to make recommendation. That is the end result, because those people are elected, and they are elected on behalf of others, and they command the confidence of many others. So again, we are asking for things that already exist just because we don't understand or we can't make the connection between our ask and what is in place. I reiterate my disappointment that the leader of the opposition misled the parliament, perhaps because he didn't read the bill or he didn't understand it, that the requirement for at least one vote from the opposition has been preserved in the alteration. Now, there is, I believe, a proper gap that we have to address, is what would be the role of the independent senators in respect of any other provision in the bill which requires a 2/3 majority. All right, so let us note that. And it comes up in the context of the confirmation vote, or in the presidential process, or not the confirmation, but the motion, that threshold, whether a ground, whether the process to remove a president should be activated. That is where there is a gap. And I think also with respect to provisions under Section 20 in the Charter of Rights, Fundamental Rights and Freedom. So there's a gap that we will have to consider. Let us hear, Jamaica. Your summary was in respect of all of those who submitted. All right. All right, we can move to the next. Sorry? Clause?
There is nothing for clause 18. And for 19 and 20, I think you've already covered those concerns for the qualification and disqualification for membership in the parliament when you spoke of dual citizenship and the foreign allegiance by your own act. Those were the concerns raised there.
Yes?
So we could move to clause 22, if that's okay.
Right, we come back to 22. We're going to come back to clause 11
Okay.
and clause 22. Let us go to the submissions on clause 26.
So firstly,
Okay.
the proposed amendment to Section 60, subsection 3 of the Constitution poses an issue, as the President would effectively be unable to prevent a bill that is in violation with the Constitution from eventually being assented to. A provision could be included outlining that a head of state may only withhold assent where he or she reasonably believes that the bill, if it were to become law, would be ultra vires the Constitution. The head of state should be required to indicate his or her withholding of assent and provide reasons to Parliament to allow them to rectify the matter by amending the provisions deemed offensive. If Parliament resubmits the bill in an unaltered form or altered in a manner that fails to address the original issue identified by the President or creates a new constitutional issue, the President should be empowered to refer the matter to the Supreme Court for a final determination on the matter. Another group said that the President, while respecting parliamentary sovereignty as the elected voice of the people, can and should be seen as a source of checks and balances against elected politicians. The President should promulgate acts of Parliament within 30 days. And before this period expires, the President should be empowered to require the Parliament to reconsider the act or specific sections of the act. This request should be limited to a single reconsideration, and additionally, the President should be empowered to refer the situation to the Supreme Court for a ruling on its constitutional validity before assent.
So this really raises, at the heart of it is what is the role of the head of state in the legislative process. That's the crux of it. Currently, the role is a token role. The finishing off, the finishing touch as a token. The laws are really passed in the Houses of Parliament. And what comes to the Houses of Parliament is backed by a whole set of process before it comes in, where you have to determine the policy, and you have to go through a long process. So it is a real question. And in particular, what is the role of a non-executive president in the lawmaking process? So right now, the head of state finishes off, it's like the icing on the cake, signs, gives assent to the bill, which then makes it law. And the head of state also is empowered to promulgate regulations in certain circumstances. But the head of state acts on advice and in accordance with a cabinet or a minister and the authority of the minister in its law-making process. So it's not a standing on the own. If assent is not given to the bill does not become law, because that's the final process in the lawmaking, in that part of the lawmaking process, and then the gazetting takes place. Madam CPC, would you like to quickly just explain to those who are listening what the stages we go through? Because again, because the public has to participate in the process, they may not understand.
Okay, so once a bill is tabled and debated in the House and passed, it goes to the other House, where it's also debated. Amendments might be made, and the bill passed. If so, the bill goes back to the other house, the first house, for those amendments to be concurred with. Once that is done, then the bill has been enacted, and it goes to a procedure where the clerk to the houses will certify that the bill has been duly passed by both houses with the amendments recorded. From there, it is sent to the Governor General for the Governor General to indicate his assent by signing the same on the bill. Now, the bill would become law once the assent is received and it's published in the Gazette, unless the bill, well, the act now provides for it to come into operation at a later date. But that, in a nutshell, is the process.
All right, there is so much to learn, so much to teach for those who are not in the specific business of making laws. We will continue the process. I think we will pause here. We have a meeting of the Constitutional Reform Committee coming up at 2 o'clock. Just so we can have some cross dialogue on what is unfolding in this process. But just to be clear that the committee that takes primacy at this stage is the Joint Select Committee. All right. So we will pause here. Madam Committee Clerk, may I ask, by way of item 8, any other business, that the confirmed minutes be published? We have committed to the public that we make available the minutes of meetings, and we have been doing so in respect of the meetings of the Constitutional Reform Committee. We would also like to make the confirmed minutes of the Joint Select Committee available, and to ask that those confirmed minutes be put on the Parliament's website, and that the corrected copies be, well, shared with us ahead so we can put them on the Ministry's website and on the Road to Republic website. All right, so I know you have all of the copies, so we just need to get those, the ones, the confirmed ones. So if you can send that to us before our next meeting. All right. Is there any other business other than that business of publication of the confirmed minutes? Next Wednesday, is that it? Right, the date of our next meeting would be April 2. That's next week, Wednesday, at 10 a.m. All right. The publication of the confirmed minutes really is important to keep members of the public who are seeking out the information abreast. Those who are not able to see or may not wish to go back to the recordings, just to have those documents available for their perusal. Right, it's now 12:39. Meeting is adjourned.